Welcome back to the deep dive. Today we are stepping into the high-stakes, high-pressure world of the operating room. Imagine you are lying on that table. You trust the surgeon with your life. But then surgery goes wrong. A difficult, complicated procedure ends in a permanent injury, and naturally you assume, okay, if a doctor breaks you, they are liable for the damage. But then the court steps in and says, hold on, just because the surgery failed doesn't mean the doctor was negligent.
It is a terrifying thought for a patient, isn't it? But it's a fundamental principle of tort law. A bad outcome is not the same thing as bad medicine.
Exactly. And that is the tension we are exploring today. We are dissecting a landmark case from the Supreme Court of Illinois, Walski v. Tiesenga from 1978. It might sound like ancient history, but this case is the perfect lens to understand the modern medical malpractice system. It forces us to ask, when does a medical mistake actually cross that line into legal negligence?
And to answer that, we have a specific analytical mission for this deep dive. This isn't just a story about a botched thyroid surgery. This is a study on the standard of care. Specifically, we need to understand the evidentiary threshold required to prove it. We're going to look at when you absolutely need an expert witness, the crucial difference between a doctor's, personal preference versus a community standard, and why a jury is never allowed to choose between two reputable medical theories.
Okay, let's unpack this. Before we get to the poor patient in our case, Harriet Walski, we need to understand the rules of the game. So, generically speaking, how does a plaintiff actually prove a doctor was negligent?
Well, it's significantly harder than proving negligence in, say, a car accident.
Yeah.
In a car crash, a jury knows that running a red light is negligent. But in medicine, the jury doesn't have that background. So the general rule in medical malpractice is that the plaintiff bears the strict burden of proving the specific standard of care by which the defendant's conduct is measured.
And how do they do that? I mean, what are the actual mechanics of that proof?
Generally, it requires satisfying three distinct elements. Element 1, the standard must be established through expert testimony. You can't just ask the jury what they think is fair. Element 2, the plaintiff must then prove the doctor was unskillful or negligent in light of those specific standards, meaning they breached that standard. And element 3, that specific lack of skill caused the injury.
Okay, so you generally need an expert to say, here is the line and the doctor crossed it.
Yeah.
But let me challenge that for a second. Are there exceptions? Times when we don't need an expert, where the mistake is just so obvious that a regular person can see it.
Yes, but they are narrow. This is what's identified as the common knowledge or gross negligence exception. The rule is that if the negligence is so grossly apparent that a layperson can understand it without any medical training, no expert is needed.
Like what? What falls into that bucket?
Oh, the classic examples are leaving a surgical sponge inside a patient's abdomen, creating X-ray burns on a patient due to overexposure, or, and this is the big one, amputating the wrong limb. You don't need a neurosurgeon to tell a jury that leaving a metal clamp inside a body is bad practice. That is common knowledge.
That makes sense. If I wake up without my left leg when I went in for my right arm, I shouldn't need to pay an expert $500 an hour to tell the jury that was a mistake.
Precisely. Now, there are two other specific exceptions mentioned in the Illinois doctrine we are reviewing here from the Darling and Oligschlager cases. First, hospital bylaws or accreditation standards can sometimes serve as the standard. If the hospital has a written rule and the staff breaks it, that rule is the standard.
And the second one?
The second is from Oligschlager. It involves explicit manufacturer instructions for a drug. So if the warning label says, do not inject into an artery, and the doctor does it anyway, that instruction pamphlet itself can substitute for expert testimony.
Okay, so we have the general rule, get an expert, and we have the exceptions, gross negligence or written rules. Now, let's see how this played out in real life. Let's analyze Walski v. Tiesenga. First, what are the legally dispositive facts?
Okay, so the central figure is the patient, Harriet Walski. She had a history of thyroid problems. And crucially, for the legal analysis, she had undergone a prior thyroid surgery back in 1949 and had also received radiation treatment.
And why does that medical history matter so much legally?
Because of the anatomy. Her thyroid was markedly swollen and it was pressing on her trachea, making it hard to breathe. But because of that surgery in 49 and the radiation, the area was just a mess of massive scar tissue and adhesions. The normal anatomical landmarks, the road signs a surgeon uses to navigate, they were all obscured or displaced.
So the surgeons are kind of flying blind in a way.
To an extent, yes. The surgery was performed by Dr. Tiesenga, a general surgeon, and Dr. Walsh, who assisted. They performed a subtotal thyroidectomy. Now, here is the specific act that caused the lawsuit. There are two recurrent laryngeal nerves, one on the right, one on the left. Dr. Tiesenga identified the right nerve successfully. However, when he got to the left side, he decided not to try to identify the nerve.
Why not?
Oh.
That seems risky on its face.
He testified that because of the massive scarring, digging around to find the nerve was actually too dangerous. He was afraid he would damage it just by looking for it. So he decided to skirt the area, meaning he made a wide cut to avoid the region where he thought the nerve would be.
And the result?
The injury. Despite his efforts to skirt it, the left recurrent laryngeal nerve was cut. This caused Harriet Walski to suffer permanent vocal cord paralysis and breathing issues.
That is just tragic. So she sues, and naturally, she brings in experts to say he did it wrong. What did her experts say?
This is the pivot point of the entire case. She brought in a Dr. Berger. Dr. Berger testified, and I'm quoting here, "In my feeling, one must identify and preserve the recurrent laryngeal nerves on all occasions."
That sounds pretty damning. On all occasions.
It does, until you get to the cross-examination. On cross, Dr. Berger admitted he could only speak to his own training and his own opinion. He could not say it was a universal standard. Then, the plaintiff brought in a second expert, a Dr. Cole, who testified that the decision to identify the nerve varies from case to case.
Which doesn't help her case at all. And the defense.
Dr. Tiesenga and Dr. Walsh testified that given the minefield of scar tissue, skirting the nerve was actually the safer, better practice to avoid damaging it.
Okay, we have the setup. So what was the core legal issue?
The issue was whether the plaintiff presented sufficient evidence of a generally accepted medical standard of care to survive a motion for a directed verdict. Basically, did she prove enough to even let the jury decide the case?
And what rule of law did the court apply here? Can you state the full black-letter rule and break it down into its testable elements for us?
Sure. The court applied the rule that a plaintiff must establish a generally accepted medical standard of care to prove a prima facie case. This rule has two distinct hurdles, or elements, regarding the testimony. Element 1 is necessity. Is expert testimony required at all? In other words, is the negligence outside the common knowledge of laymen? And element 2 is sufficiency. Does the expert testimony establish a community standard versus a mere personal preference or a difference of opinion?
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply that first element, the necessity of expert testimony?
Okay, let's look at the mini IRC for necessity. The sub-issue here was, could a jury understand this negligence without an expert? Was this, a sponge left in the abdomen situation?
And the sub-rule for that?
The sub-rule is that the common knowledge exception applies only to gross negligence, where the lack of skill is just apparent to any layperson.
Okay, so how did the court apply that to Dr. Tiesenga's surgery?
Well, the court looked at the complexity. They noted the surgery was extremely difficult. You have a thyroid gland surrounded by scar tissue from prior radiation. Anatomical landmarks are displaced. The decision of whether to skirt a nerve or identify a nerve in that specific scarred environment is highly technical. A layperson has no frame of reference for that.
So, the conclusion on element 1.
The common knowledge exception failed. Expert testimony was absolutely mandatory.
Understood. So Harriet Walski had to have an expert. She brought Dr. Berger. Now, what about the second element? The sufficiency of the expert testimony provided by Dr. Berger.
This is where the plaintiff's case just completely fell apart. Let's mini-IRAC the sufficiency element. The sub-issue was, did Dr. Berger's testimony actually establish a standard of care that Dr. Tiesenga breached?
And the sub-rule on that point.
The proof of a standard requires evidence of generally accepted practice. It is not enough to show that another doctor would have acted differently. As the court noted, medicine is not an exact science. The plaintiff has to show the defendant's method was not accepted by the medical community.
And the application. How did they view Dr. Berger's words?
They scrutinized them very closely. Dr. Berger used phrases like, "in my feeling," and "I can only speak from my own training." He testified about what he would do. Crucially, he did not testify that skirting the nerve was unacceptable to the medical community at large. He essentially said, "I was trained to find the nerve," but he had to admit others might be trained differently.
And her other expert, Dr. Cole, he didn't help either, right?
No, not at all. Dr. Cole admitted the procedure varies, and then the defense came in and argued that skirting was actually the better practice in this specific scenario.
So what was the conclusion on that second element?
The testimony only showed a difference of opinion, not a breach of a standard. The court held that a jury cannot be allowed to choose between two conflicting methods if both are recognized, or if the plaintiff fails to show the defendant's method was forbidden.
And after analyzing all the elements, what was the court's final conclusion?
The Supreme Court affirmed the directed verdict for the defendants. Because there was no evidence of a specific, generally accepted standard that was violated, there was simply no factual question for the jury to resolve. The plaintiff failed to make a prima facie case. The case was over before the jury even got to deliberate.
It feels harsh, doesn't it? The woman has a paralyzed vocal cord. But the law says, sorry, you didn't prove everyone agrees this was wrong.
It does feel harsh, but you have to consider the alternative. If we allowed liability every time a surgery went wrong, or every time one doctor disagreed with another's technique, medicine would grind to a halt. Doctors would be too afraid to operate on difficult cases like Harriet Walski's.
That is a fair point. Okay, I want to make sure this distinction really sticks for our listener. Let's do some visceral hypotheticals. I'm going to present a scenario, and I want you to tell me if the gross negligence exception applies, or if we are stuck in that professional judgment zone where Walski lost.
Go ahead.
Hypothetical A. A surgeon is removing a thyroid, exactly like in the Walski case. The surgery is going fine. But halfway through, the surgeon gets distracted and accidentally leaves a large metal retractor inside the patient's throat before sewing them up. The patient wakes up choking.
That is gross negligence.
Oh.
100%. Because the analysis is visceral and obvious. A jury doesn't need a medical degree to know metal tools shouldn't stay inside the body. No expert is needed. This is res ipsa loquitur. The thing speaks for itself. The error is so gross that common knowledge is sufficient to prove negligence.
Okay, now contrast that with hypothetical B. The surgeon is navigating a minefield of scar tissue, just like Dr. Tiesenga. One school of medical thought says, dig until you find the nerve so you don't hit it. The other school says, don't dig near the nerve at all. Stay far away to be safe. The surgeon chooses the stay-away method, but the nerve still gets cut.
This is the Walski scenario, and it is not negligence.
Explain the difference.
The difference is professional judgment. If the surgeon chooses the stay-away method, and it is a recognized, reputable method, the bad outcome is a tragedy, but it's not a tort. Unless an expert can say the stay-away method is absolutely forbidden by the medical community, it's just a judgment call. A jury cannot look at two valid medical options and decide which one they like better.
That really brings it into focus. It's not about the injury. It's about the choice the doctor made before the injury.
Precisely. That's the heart of it.
Okay, we've covered a lot of ground. We've got general rules, exceptions, the specific failure of the expert in Walski. For our listener who might be prepping for a deeper understanding of malpractice law, let's synthesize this. Can you give us a medical malpractice standard of care diagnostic checklist?
Certainly. If you are looking at a fact pattern or a real-life case, you can run through these 4 steps in order to diagnose the issue.
Step 1.
1. Check for common knowledge. Is the error gross and obvious? Is it a sponge left inside, a wrong limb amputated, or an X-ray burn? If the answer is yes, you stop there. No expert needed. It's gross negligence.
And if it's not that obvious, step 2.
Check for written standards. Are there any hospital bylaws, accreditation standards, or explicit manufacturer instructions like the warning label in Olerschlager? If yes, these may substitute for expert testimony.
Okay, and if we don't have those either, step 3.
3. Evaluate expert testimony. If an expert is required, you have to scrutinize their language. Did they say, I would have done X? That's insufficient. It's just personal preference. Or did they say, standard practice requires X? That is sufficient. It establishes a general standard.
And finally, step 4.
4. The 2 schools doctrine. If the evidence shows 2 conflicting but acceptable methods, like identify versus skirt, and the defendant followed one of them, there is no negligence. A jury cannot pick a winner between 2 valid medical options.
That is a powerful framework. It really highlights that standard of care isn't just a vibe, it's a rigorous legal construct.
It is, and it exists to protect the medical profession from being second-guessed by hindsight every time there's a bad result.
So as we wrap up this deep dive, the key takeaway really seems to be this. In law, as in medicine, a bad outcome does not automatically mean bad practice. You can do everything right, or at least everything acceptably, and things can still go horribly wrong.
That is the hard truth of the profession and of the law that governs it.
And here's a thought I want to leave you with, something to mull over. We saw Dr. Berger testify that in his feeling, the nerve must always be identified, but he couldn't say it was a community standard. It makes you wonder, if a doctor testifies against another doctor, are they defending the standards of medicine? Or are they just defending their own ego and training?
That's a fascinating question about objectivity in a field that is, by its very nature, so subjective.
Indeed. We'll see you in the next deep dive.